Civil Shells Property Owners Association, et al. Counsel, are you ready to proceed?
Yes, Your Honor.
You may approach, counsel.
Thank you.
Again, we'll allocate 20 minutes per side for this oral argument. Would you like to reserve some time for rebuttal, counsel?
I would, Your Honor. 7 minutes, please.
Don't note it, Madam Clerk. You may continue when you're ready, counsel.
Good morning, Your Honors. Raymond Rafel, representing New Ventures and Damon Becknell. This is a situation where the court has entered an order, as the court is well aware, on a motion for summary judgment. There were actually 2 motions for summary judgment heard at the same time. There was a motion for summary judgment that was heard by the appellees and also by the appellants. The appellants was denied. Everything that's in my brief, in the event that I do not address those in the reply initial brief, we're reserving as to those with the arguments. And of course, if I don't address it in an oral argument, we are not waiving that. So the issue that we have, Your Honors, is that, number one, the standard of review is de novo. And there's de novo in this case for not only the summary judgment, but also the construction of the declaration, which of course is the contract, but also the backbone of our condominium laws. So in this particular case, what the court did, in our opinion, was, number one, granted summary judgment when it should not have done that in the lack of evidence that was presented. The other is, of course, we believe that the court misconstrued and misinterpreted the declaration and the amendments to the declaration. And then finally, the court also, and this goes to another de novo, misapplied the law on relative to what we call the Fourth Amendment. And I'm going to address that because that seems to be the flag that's often waved in this case, which is my client did something as to fraud because the date on the amendment was not the date he signed it, and a notary signed it at the same time when there was, in fact, a different date.
Before you get to all of that, can
Yes.
you address why there's jurisdiction here, how this qualifies as an appealable non-final order?
Yes,
I mean, it's an order granting summary judgment on 3 counts, one unfortunately labeled injunctive relief, but I mean, we talked about this case, or we talked about a similar issue in the city of Newberry versus Alachua County a few years ago, talking about just granting of summary judgment on a count that, as part of its relief or prayer, seeks injunctive relief, is not the same as ordering an injunction at that moment. So can you address
Yes,
that?
I'll address that. It's our opinion, Your Honor, and of course subject always to your rulings, that this is a situation where it's not only just an injunction, but an immediate possession of property.
Sure, but I mean, it's the same thing. I didn't mean to put them in the same category. So it's the count 3 sought injunctive relief. Generally speaking, you're characterizing this as immediate possession of property. I'm assuming, I mean, I looked up the CCIS, there's been no bond filed, there's been no stay sought, there's no threat of actual execution on any sort of order of immediate possession. And presumably that's because you don't have a final judgment yet, as the trial court itself said in its order.
Well, in the order, it did grant them the right to immediate possession of the property.
Granted the motion for summary judgment and said that there would be a right to immediate possession. It's a granting of the summary judgment. There's no judgment here on which to grant a remedy, which is typically required. You have to have a judgment first before you get a remedy. And this is not a temporary injunction situation, so there's no order of keeping the status quo that you're appealing. You're appealing the merits of an interim summary judgment that happened to, if it becomes final, would result in injunctive relief, which is different to me.
I understand what you're saying. I disagree respectfully because you're saying, well, the next step is you get the same judgment with the same language, and I don't believe that's necessarily what the order does. I believe
after you have the trial on the other 2 counts, I saw that there was a notice for trial filed, and so the case is still pending. There's still trial awaiting for 2 counts. It's not over yet, and so what is the right now? there's just a summary judgment granted. It's not granting any relief. Are you under threat of, have they sought to transfer the property and force the summary judgment at this point?
First of all, they have not done that yet. That doesn't mean that's not something that they will do. They will do that.
How would they do that on a partial
I-
or interim summary judgment?
Well, I believe that this order is a partial summary judgment order for final. I don't agree that this is a aspect relative to they get to come back. What is there else to do?
Well,
No.
I think the trial court actually explicitly declined to enter final judgment. It reserved ruling, and it said I'll enter final judgment after these remaining counts are resolved. And I came across a case that's pretty similar out of the 3rd DCA, where the court said the trial court simply granted the motion for summary judgment but did not enter a judgment or issue a writ of possession. Therefore, there was no jurisdiction under the narrow circumstances of 9.130. I'm similar to Judge Tannenbaum. I'm having a hard time seeing our jurisdictional basis here.
Okay. Well, I understand what you're saying. Number one, I would say that nobody has argued that, so I'm coming in a little, less prepared than I would have liked to be. I'll be quite honest with you. With regard to that, and I'm looking at the order now, is what I'm looking at, just so you understand. I don't necessarily, it says the court will enter final judgment on these counts, which is what you read, Judge Ray, on these counts upon resolution of the remaining claims in the case. So to the extent that you believe that this isn't, for them, they cannot go and get a deed, or because this is what the injunction orders, is for us to give them the property, and this is, in fact, an order in that point, I believe that the court, that requires, if they did enforce that aspect, that we would have to do that. The final judgment is based on, it says, on these counts upon resolution of the remaining counts. The remaining counts.
But wouldn't you then have relief? You could come to us, seek a writ of prohibition or something, because a trial court can't grant relief, can't give you a remedy until there's a final judgment. That's what a final judgment is. It's the actual relief. It's the end of the case, and it changes the legal relationship between the parties and creates obligations. There's no judgment right now changing the relationship or creating obligations. There's just an order granting the motion and explaining why it's granting the motion.
Right. So again, I don't disagree with you, Judge. The aspects, though, is that where we are on this is you're basically saying, okay, you have a grant of a summary judgment. We're going to wait until the court hears one other count, which is on the aspect of their claim of a fraudulent document that was filed, and then 2 other counts that they've already tried to move forward in the trial court to say because those were abated because we had this, what we call the sandbar case, which is also up on appeal here in front of the court. And one reason that we haven't, I presume, you can ask them, is because the sandbar case, if it's overruled by this court, then affects this case. If it's not, then it becomes almost a res judicata aspect to a certain extent. There are some things that are slightly different, but then they would do that. They've already moved for the unabatement. Yes, Judge?
No, I'm just thinking, it seems to me like if you have an order granting summary judgment, then the case law says typically it's not appealable.
It's true. We just viewed this as a aspect of when they granted it and ordered that it would be, because the injunction, of course, being there's a negative and a positive that's an injunction, were to do something when they granted that injunction that we are now supposed to provide the property to them. We believe that that was an injunction with immediate possession.
Well, but count 3, I mean, it's labeled injunctive relief, and I question, well, what are the elements of a cause of action for injunctive relief? Injunctive relief is a remedy. It's not its own cause of action. So which count 1 or count 2, was injunctive relief being sought?
It's count 3 is what they have.
Yeah, but count 3, is not, it can't be a standalone count. So even though it stood there and no one said anything about it, there are not elements to a injunctive relief cause of action. Injunctive relief is a remedy tied to a cause of action in some way, statutory, common law, something. So is it the declaratory judgment count, or is it the breach of contract count?
Well, I disagree.
Or
that
is this a specific performance labeled as injunctive?
That's what
relief
we
count?
argued. We said this is not injunction. This is specific performance that you've called an injunction because you're requiring that we provide you with the real property. That's our argument, because we also address whether that in fact is under a statute of frauds, statute of limitations issue, because of course you know it's a 1-year statute of limitations. So we have said that you call this an injunction, but it's a specific performance, which is what we addressed in our brief too. However, the court, regardless of what it called, and again, I don't agree with the trial court's reasonings or the law or anything like that, it adopted almost substantially the Pelley's order, which again, we didn't agree with. So in this case, it says here, according this court will enforce the plain language of the declaration and requires, this is where we get this, and requires New Venture to transfer title to all common properties listed in the declaration as of the 20-year date, May 27, 2019. And then it says these are it, so this order does require that we are supposed to transfer. I don't disagree with you, Judge. I think it's a specific performance, but that's not what the judge ruled. And I do know that there are specific counts for a permanent injunction that are standalone. They didn't necessarily allege that. Again, I agree with you. This is a specific performance, but the court did order us. And I understand you say, but, you know, Rafel, we got to have a final judgment. I don't disagree with you on that either. However, with this, the reason being that we're here is because it's requiring the transfer. Have they enforced this order yet? They have not. Can they enforce this? I believe they can, which is why we're here. And if we didn't file this and we didn't come here and we didn't say this was wrong, I believe the next step would have been knocking on my client's door saying, where's our deed?
Right, and then you'd have something you can do, because there's interim relief, which is typically to maintain a status quo. That's really the full scope of a trial court's authority pre-judgment, is to just maintain the status quo and control the parties. Cannot grant interim relief before there's an adjudication of the facts and a judgment entered. You don't have a judgment entered. You have an interim motion for summary judgment that was granted that ultimately will lead to the entry of a judgment. I don't know why you didn't seek a partial final judgment if what you're saying is that there's just one other count and it's regarding a separate party, and this qualifies as a partial final judgment. But that's not why it's here. It's here because it happened to be on a count that is labeled injunctive relief, I assume.
Okay. I think it would not be prudent of me to go and get a judgment against my client for this, to be quite honest. I don't. And when I have an order that says you will transfer, then to me that's an immediate possession. So perhaps you disagree with the process, and I understand that, and by all means, you are the judge. But at the same time is when I've got an order that tells me what exactly I read, and it says transfer title, that to me means that this court has already adjudicated. And when you look at this and you say, okay, what else, Rafel, does this need to be done? Okay, what other judicial work needs to be done on counts 1, 2, and 3? According to this, nothing. Because the court says we don't have the time for you already took it out. Now we have the aspects of the turnover, which we believe is the wrong thing. He says turnover occurred. You were supposed to do this. We find that turnover already occurred. Now, because of this, and to your point, hey, count 3 is not really an independent count, but to your point, count 1 and 2, he grants 3. And then he says here to transfer all title. So if I look at this as which is what we did, we said this is an order of immediate possession because it doesn't say transfer upon a final judgment.
Well, so I cut you off at the beginning when you were talking about standards of review, but now we've come full circle. So if it's only the injunctive relief part, or the specific performance, as you would call it, or the ordering of your client to do something immediately, wouldn't it just be count 3? And what's the authority for us to then be considering counts 1 and 2? And typically, when we're considering injunctive relief in an interim or an interlocutory order, maintain the status quo, we have a standard review for that. But that's not going to apply here. You want us to look at all the merits of the whole thing before it's a final order. So how are we supposed to approach it if we take it your way?
Because you can't have you can't get to 3 until you have 1 and 2. So you have to, if you did this logically by math, to come up with the number 2, you'd have to have a 1 plus a 1 equals 2. This you don't have. You can't have that. There's not, if you say, okay, I agree now, argument-wise, that this is an appealable aspect. How is this error then? Because you have to look at 1 and 2 to see how the court got to 3. So back to your point, Judge, if you find that this is not, because I still think it's a specific performance count, but if you come to and you say it's just an injunction count, then you still have to say, well, that's relief. What was the relief? Immediate possession. How did he get it? Because of what he found on turnover. So why I think that, and I'm familiar with the aspects of the appellate review, which is if it's tied to an issue that is permissible for the court to determine, the court can look at the other issues that may not have been reviewable on their own. But because the court did what it did, this is where we are. This is why it's an immediate possession. And I submit to the court that that has not been raised at any point by the appellee.
Counsel, this is not meant to be a gotcha, the jurisdictional question.
I don't think so. I think it's a good question. I wish I had prepared.
Well, no, I mean, and you're obviously well prepared. The briefs were excellent by both counsel. It's just jurisdiction is something that we have to continue to assess, and our jurisdiction in an interlocutory review is quite narrow. And so I appreciate the references to the order that you believe, rise to the level of immediate possession of property, and that's just something that we need to assess when there hasn't been a final judgment and when there hasn't been a writ or anything that the court could execute or their client could execute on by virtue of this order. So that's just something we're struggling. It's not intended to be a gotcha.
No, I certainly did not take that. I mean, I've been doing this long enough. You should have some idea of everything that's going to happen. And I do think it's a good point, considering that we considered that point to start, because it's very well known that the granting of a summary judgment until it's changed by rule is not an appealable aspect. So what we did is, of course, we did evaluate that. So it's not something that, I certainly don't think it's a gotcha. I certainly do not. But it is something that we considered. And I do think that based on this, we have the right appellate review. I would reserve, I'm not sure what for, but I'm already at a loss. Thank you.
You may continue, counsel.
Thank you. May it please the court, name is Kent Seyfried with the law firm of Holtzman Vogel on behalf of Appalachia Silver Shells Property Owners Association. Like my colleague, I was here to obviously discuss the merits of the case and make that argument, but in light of, I guess, the jurisdictional questions, that needs to be addressed first. And I think with respect to the questions, it's a valid question. I don't think there is jurisdiction here with respect to this summary judgment order, because there is no final judgment. To that point, how does that get remedied or cured? Obviously, we go back to the trial court. We get a final judgment that basically says the same thing it says here, except with a title of final judgment.
And dispose of the rest of the case.
I'm sorry?
And dispose of the rest of the case or characterize it as a partial final judgment, right?
That's correct, Your Honor. And so we could be back here in that same posture with a partial final judgment where the court would have jurisdiction. But
Is
yeah.
that your position, that everything has been disposed of as to these parties?
No, Your Honor. With respect to, there's two more counts, I
I mean,
believe.
there's the Reformation count still. isn't there?
That's correct, but I think by if counts 1 through 3 stand and are affirmed, the Reformation count is moot, I
Yeah, but
believe.
see, you're both highlighting why we have the rules that we have regarding final orders and non-final orders. The 9130 is not intended to be a backdoor way to get review for the benefit of the parties so they know what to do with the rest of their counts. You filed a complaint, you have a number of counts, one of them has not been resolved, or two of them have not been resolved yet. Don't you need to finish the case and then get a judgment, and then, someone can come up to us and ask for a review of the whole thing?
Yeah,
In
that-
one wrapped up in a bow.
Yeah, you're absolutely right, Your Honor. It does need to get finished, and my client is wanting to get this case finished and finalized and have, one appeal and be done with it.
The trial court could have entered a partial final judgment on counts 1, 2, and 3, is that correct?
I'm sorry?
The trial court could have entered a partial final judgment as to the counts on appeal,
He could have, yes, sir.
Well, that's
and
what I
that
was
would have
just
been
asking.
appealable.
In my opinion, yes, Your Honor.
But that's what I was just asking you. I mean, the Reformation count, count 5, I understand, that seems to be completely separate. Not completely, but it obviously deals with a separate issue regarding one of the parties. But count 4 is reformation about the same documents that counts 1, 2, and 3 are about, isn't it?
That's correct, yes, sir.
So help me understand how there could be a partial final judgment as defined by the appellate rules when you have a count outstanding related to the issues that counts 1, 2, and 3 are related to.
I can't explain that, Your Honor. I agree with you that it's not a final judgment in this
Right, but it
case.
couldn't be a partial final judgment either, because you have one count, count 4, that relates to the parties that are here on appeal now, the appellants, and the documents that are at issue that hasn't been resolved, disposed of, or dismissed.
I'm not sure exactly about that. You're going to have to go back and look at the equitable reformation count, but my memory serves to say that count dealt with the Beach Amendment to reform the document to invalidate the Beach Amendment, and that Beach Amendment that was executed, I believe, in 2001, 2002, has been resolved by the settlement with Silver Shells LLC. That's why I said earlier, I think maybe that equitable reformation count is moot at this point.
Still, we have sake of argument that we affirmed the trial court in this case. What is left for the trial court to determine in the proceedings below?
The only thing that's left, Your Honor, is count 5, which is liability under section 817.535 that goes to the fraudulent fraudulent execution and recording of the 2019 amendment that attempted to remove common property from the condo association after turnover occurred. And that was a document that was signed or dated January 1 by Mr. Damon Becknell, both in the document and in the notary jurat. And that was done sometime between February and July 1. Nobody knows when it was done. The notary signed that document knowing that that date was fraud. And so that's the count for liability and damages relating to that is to be tried.
And against whom would that judgment, against whom are you seeking that judgment?
It would be New Ventures, it would be Damon Becknell and the notary, Mrs.
So the same
Corfonta.
parties, so at least two of the parties that are present now.
That's correct.
On appeal.
That's correct.
So I guess, and those facts that seem, or at least somewhat related, imagine some of the evidence that you would rely on for count 5 show up in the 2,000 pages of appendix for counts 1, 2, and 3, right?
That's correct, Your Honor. And there's also counterclaims pending by New Ventures that deal with the declaration as well, that will have to be resolved.
Can the parties go back to the trial court and get an appealable final judgment as to the appeal counts?
As to these 3 counts,
Yes.
I wouldn't think so, based on the arguments here today.
Well, I'm not making any arguments, I'm just asking the question.
Yeah, if the court doesn't view this order as requiring, the immediate transfer of property as counsel argued, then no, it can get there will be no final judgment on counts 1, 2, and 3, in my opinion.
Can you explain what count 3 is? I see practitioners do this. I've seen it for 20 years when I was a civil litigator. Why is there a separate count called injunctive relief? I've seen counts where there's a count for declaratory judgment relief. Is this, what is count 3?
It is a count entitled injunction, but I think Your Honor is right, and my colleague is right here. It really is a remedy of specific performance upon the breach of contract claim for count 1. I inherited this case about on the 3rd amended complaint, so I did not draft these original counts, so I can't give you specific insight as to why that count was drafted like that.
But if it were really, in reality, a specific performance remedy being sought, it would be tied to count 1?
It would be tied to count 1, which is breach of contract, wherein the trial court found that New Ventures breached the declaration by not transferring these two pieces of common property at turnover, which was May 27th, 2019. And its failure to do that, the remedy is transfer it now.
But does that cause a problem? Because count 1 seeks compensatory damages, which seems to be, unless I got that wrong, maybe it was a previous complaint, but I think count 1 seeks compensatory damages for breach of contract. Can you seek specific performance and compensatory damages for breach of contract at the same time?
Yeah, I think you can for the damages for the temporary time period in which you did not possess the land. So our unit owners have been dispossessed of that land from 2019 through whenever time the court orders or the actual property is turned over. So yes, I think you can recover both during those time frames.
And how much in damages has the trial court given you?
They didn't award any damages with respect to counts 1 through count 3. I think the court was granting the injunctive relief there on count 3.
Are
Possession
you
of the
still
property.
seeking compensatory damages? Is that going to be a subsequent hearing where the trial court's going to have to resolve it?
I don't know, Your Honor. I don't think so, but maybe. I'll have to go back
I mean,
and
you can
look at
see
the
all the
pleadings.
problems that develop when parties come to this court mid-case to have certain legal issues that they're interested in having resolved. I mean, for me, there's lots of loose ends that could be problematic if, we were to rule on the merits of one part without knowing how the case is ultimately going to end. But I've beaten the dead horse. I've beaten the dead horse, clearly, so I will stop asking about it.
Understand, thank you.
Before you sit down, again, what's to prevent the trial court, assuming for the sake of argument, that we dismiss this appeal for lack of jurisdiction, from entering in the proceedings below an appealable partial final judgment as to the appeal 3 counts?
Well, I think what the argument is here, and again, I haven't researched this and prepared for this very question, but I think there's other interrelated counts, both in the counterclaim as well as still left, count 4, the equitable reformation, if it's not moot, that might prevent the trial court from doing that. So without going back and looking and researching it specifically, I don't know that I can stand here today and say that the trial court can or cannot enter a partial final summary judgment on these 3 counts.
And I didn't focus on it before, but do any of the counterclaims seek an offset, a sort of counter compensatory damages that would serve as an offset in the case if they were successful?
No, I don't
Maybe a
believe.
question I should ask.
I don't believe any of those counterclaims would. There's a counterclaim for seeking to invalidate a amendment that the SSPOA made after turnover, so that's unrelated to counts 1, 2, and 3. There's also a slander of title count still pending on the counterclaim, which alleges their title was slandered by our Les Pendens when we filed it with respect to the 2 common properties at issue.
Are they
But no, I don't
seeking
think there's any counter.
Damages for that?
So, yeah, they are seeking damages for that.
Right. So if they were successful on that count, that might serve as an offset on any damages you were seeking on count 1?
Well, they can't be successful on that count if you affirm counts 1 and 2 and 3 in this case, because they're saying the Les Pendens on that common property slandered their title. The judge has ruled for us saying we're entitled to that property, so that count would arguably be dismissed, consistent with counts 1 and 2.
Sure, but as we stand right now, what is the status of their counterclaims?
It's pending. If there's no other questions, thank you.
Sure. I think you have some rebuttal time left.
So the equitable reformation deals with the same properties for the court's benefit. That's at count 4 of theirs. Count 5 is completely separate, dealing with what we say is a non-issue on the date. And we've said, but if the court is concerned, because I hear Judge Lewis, and he's correct, a final order is when there is nothing left for the court to do. And why didn't we do a partial final order, a final judgment? Also very good questions. There's nothing left to do because you can't have compensatory and specific performance. And as the court's aware, specific performance is permitted for real estate because it's of a unique character. That's what they sought. That's what they obtained. If the court still has issues with whether this is an immediate possession or appealable, then would the court entertain an Ortenis motion to reserve and relinquish jurisdiction for a partial final judgment based on the counts 1, 2, and 3, again, count 3 being what it is, and then we can proceed forward in that regard, because I do appreciate that our clients have put in substantial fees that we've charged and everything, and I do think that where we're going to end back up is even if we go back to court and get the judgment, we're still going to come back on the same issues. So I would just ask the court if they would entertain that. That would be appreciated, at least by my clients.
Thank you, counsel. We'll take it under advisement.
Thank you very much.
This concludes our oral arguments for this morning. We are adjourned.